Welcome to our channel, ladies and gentlemen. I would really take this opportunity to thank you for your continued support to this channel, and on the same breath request you to hit that subscribe button if you're watching us for the first time, and click the notification bell so that YouTube will notify you whenever we release a video like this. You can also like our videos and share them, and I would really appreciate you. This is the kind of support that you can render to us. This is our channel and we grow together. Thank you very much. Now, there is a legal battle that is looming between the Azimio Deputy Principal, Madam Martha Karua, the Iron Lady, and the Attorney General, who is the Chief Legal Advisor to the government. And this concerns or pertains the presidential ruling from the Apex Court that upheld the victory of William Ruto, as was pronounced by the IEBC. After the ruling that Martha Karua termed non-judicial, because of the non-judicial terms like hot air and wild goose chase that were used by the president of the court, Madam Martha Koome, Martha Karua and the Supreme Human Rights Chairperson, Khalifa Halif, went to the Arusha-based Court of Justice, the East African Court of Justice, seeking interpretation into the matter because Martha Karua obviously was never satisfied with the ruling. And remember, this is not the first time that Martha has sought an interpretation from the East African Court of Justice. In 2017, when Martha felt that the government of the day rigged her of her victory and gave it to Madam Anne Waiguru, who is now the chairperson of the Council of Governors, Martha rushed to the Arusha court and she sought legal interpretation, and I think she was given some relief because it was ruled that some of her rights were plunged on, and I think there's some money that she was given. She won that case. And now she went there again on a second opinion concerning the ruling of the Supreme Court. This prompted the Attorney General, JB Muturi, who also went to the Apex Court to seek another interpretation as to whether the decision of Supreme Court in Kenya can be overturned or reviewed by any other international court, whether it is the Hague-based court or the East African Court of Justice. Because according to him, he felt that once a ruling has been pronounced by the Supreme Court, which is the highest court in the land, then there is no any other justification for seeking a second opinion. Second to that, JB Muturi wanted the Apex Court to pronounce itself on the legal ramification of such a ruling. For example, if the East African-based court will rule that the Supreme Court aid in their ruling, then what will be the result? What will be the implication on the sovereignty of the Kenyan nation? Will it be going against our autonomy because Kenya is an autonomous country? And what is the legal implication on the will of the people? So Attorney General went there to seek that opinion. Now, the Supreme Court ruled that Martha Karua, being the interested party, the engineer of this, should be allowed to give her opinion. And in their ruling, the Supreme Court pronounced as follows: that we are of the view that Karua has an interest in the case in light of the suits she has filed before the East African Court of Justice, In the pertaining circumstances, her participation is essential for her to put forth her position and for us to appreciate diverse positions concerning the subject dispute. That was the ruling. Now, Karua has been accepted to be part and parcel of this legal battle. Apparently, Attorney General did not want Karua to be enjoined in this case. But the Supreme Court said that in order to enjoy diversity of opinions, because this will shape the manner in which they move forward with their rulings as a case study, so they allowed Martha Karua. Martha Karua obviously sees something that is very intended with what other Kenyans feel, that our courts are never independent. Because when Muturi says that if another court will interpret or have an interpretation to what has already been pronounced by the Supreme Court, then this will be infringing on the rights of our courts and the rights of Kenya as a sovereign nation. Then I will tell you that when we talk about sovereignty, we start with Kenya before we go to the courts. Kenya is only independent on theory, on paper, because you've realized by now that we are being ruled by the international community. Very many leaders, including the leaders from Kenya Kwanza, now understand what we have been making noise about, that it is the USA together with the other European nations that gave Ruto the victory. And therefore William Ruto has to dance to their tune. Let me give you an example. Recently, the Nyali Member of Parliament, Muhammad Ali, lamented that America is forcing Ruto to accept same-sex marriage, gay and lesbian, and that we are never allowed to enjoy our sovereignty. And this tells you that William Ruto will always do that which the US and the UK wants. And I need not to mention things like LGBTQ, GMO, raising taxes, removal of the subsidies. These are things that we all understand that are dictates from the West. So when we talk about the sovereignty of our nation, we are lying to ourselves. We are never a sovereign nation, or we are supposed to be, but we are still. This is neo-colonialism that is still happening in Kenya. When you come back to our courts, the independence of the court is in question. Just recently, Martha Koome alluded to a fact that there is a gap between the common man or the citizens and the judiciary, that the citizenry does not trust the judiciary in terms of their rulings. Lawyer Ahmed Nasir keeps on saying that when you go to our courts, they will rule in favor of the highest bidder, and has been making noise about corruption in our courts. Whenever there is corruption that is ruling our courts, then you know that the court is never independent, because they are ruled by money. Not only that, our courts have been subdued by the executive. They have been pocketed, and they will always rule in favor of the executive. This is the court that gave us Ruto's win, something that is still contested. This is the court that gave us the LGBTQ and telling us that those people have got the right of association, knowing very well that it is against our culture and it is something that we don't accept. And this is the court that is about to pronounce itself on the infamous Finance Bill 2023 that has forced the Energy and Petroleum Regulatory Authority to increase prices of petroleum products to a level that has never been witnessed before in Kenya. So this is a court that we don't trust. No wonder Martha Karua went to the East African Court of Justice. So the independence of the court is something that a fallacy. JB Muturi says that it is infringing on the will of the people. And at this point in time, allow me to ask you, what is the definition of the will of the people? Because on 2 occasions, the Kenya Kwanza team claimed that there have been attempts to subvert the will of the people. One when they claim that there were eminent people who went to Bomas to force Wafula Chebukati to pronounce Raila as the winner. And in that, they even claimed in the Supreme Court during the presidential case that these people went to subvert the will of the people. And now, JB Muturi is saying that by Martha Karua going to the Arusha court, once they pronounce themselves against a ruling that has been pronounced by our court, then that is subversion of the will of the people. Martha Karua on her side also went to that court saying that when the courts upheld the victory of William Ruto, they went and against the will of the people, they subverted the will of the people. So my question is, what is the will of the people? Because I remember even when the Kenyan parliament was about to debate and vote on the Finance Bill 2023, people had gone for what we call public participation, and almost all Kenyans who talked there said that they were never ready for the Finance Bill. But their will was never listened to. And that is what I call the will of the people. When people pronounce themselves on a matter and you ignore them, that is what I feel is the will of the people. And the question is, between the Kenya Kwanza team and the Azimio, or between the Supreme Court and what Martha Karua is now talking about, who really subverted the will of the people? Is it the Supreme Court by pronouncing that pronouncing that William Ruto was the president, upholding that rule? Or, as it is claimed, the Azimio or the eminent people who wanted Raila to be declared the winner? I want to end by saying this. Let us open the server so that we stop the definition of the will of the people. The server will tell us who really wanted to subvert the will of the people, and expect a really fierce battle between the Attorney General and Martha Karua, because this is going to resuscitate something that we always want to forget: the issue of the server, the issue of the bombers, and the issue of the Supreme Court, and the hot air and the wild goose chase. What is your take?